offices located in various locations as USA, Mexico, and India. And Cogent IBS is a SAP partner specializing in providing SAP project consulting services, product development, RPA solutions, and staff augmentation services. And Cogent has been hiring talent across the globe by extending many types of immigration visa routes, such as H1B, TN visa, E3 visa, and L1 visa, and visa categories, as well as the green card. We often do the green card also as well to the next to the citizenship path. Yeah. And we work closely with attorneys, and we share a good connection with Joseph Kalabat attorney, Joseph Kalabat Associates here. And Joseph Kalabat Associates, they are based in Michigan location, are focused on serving its clients, businesses, professional services, and also specializes in employment-based immigration as well as family-based immigration matters and corporate law. Joseph Kalabat Associates and PC continues to provide their clients with a full spectrum of immigration services. We are happy to share their approach on complex immigration issues and legal matters are outstanding. And here today with us in this call, we have attorney from Joseph Kalabat office. We have Michelle and Scarlett on our team right now to have this call. Michelle Kashmika, she has received her Bachelor of Art degree in English Language and Literature from Wayne State University and her Juris Doctorate from the University of Detroit, where she was awarded Dean Scholarship for Excellence. Michelle is a member of the State Bar of Michigan, admitted to practice before the United States District Court for the Eastern District of Michigan. And we also have Scarlett in this team right now. And Scarlett Akkam received her Bachelor of Science Social Work from Michigan State University and a Juris Doctorate in Law from the University of Detroit. Scarlett is an active member of Michigan Bar Association. We've been working for years with them on the H1B and green card process, etc. Now it's over to Michelle and Scarlett to talk about the green card H1B right now. Today's topic is going to be on the H1B. And after basically on the H1B Cap, we will happy to take calls on the immigration questions in generic questions. If it is specific petitions, we'll be dealing later. Generic questions we'll be talking about in this call. Thanks a lot, Ravi. Thanks, Michelle and Scarlett. Please go ahead. Thanks you.
Thank you, Usha. So Scarlett is actually our senior attorney at the firm. She has a very distinguished expertise in the H1B as well as the green card process, which is a 3-stage process. The point of this PowerPoint and also the overview of the H1B is a general understanding of the H1B. Of course, there's going to be specific and case-specific questions that we're always happy to address during the Q&A. But hopefully this is, this is an ongoing thing where if you guys have specific questions about specific topics, we can always organize these, webinars around what's going to be most helpful for the participants. So any feedback or anything like that, you're always welcome to, ask for specifics to either me or Joe or Usha, whoever is easier for you to contact. So I don't know if Scarlett wants to give a few introductory words as well.
Hi, like Michelle has said, my name is Scarlett Akkam. I've been at the office here about 10 years with Joseph Kalabat and Associates. We specialize in employment-based immigration. I've been doing the I-140s, 485s, and H-1Bs basically since I started around 2014. And we're here happy to help you guys with any questions you have, and I'll let Michelle lead us into our discussion today on H-1Bs.
Thank you so much, Scarlett. Thank you, Usha, and the participants. So today we're going to go over generally how to get on the H-1B. You can get on it by, coming from abroad after being selected in CAP. Or you can change status from F1 to H1B, L1 to H1B, B1 to H1B. It would just kind of depend on what your status is and if you're even eligible, because there's going to be something we're going to discuss that's called immigrant intent. And that's kind of the foundation for whether you'd be eligible to ever change status. And that conversation's for the individuals who are already in the United States. The individuals who are joining us from India, first of all, thank you for being on here so early in the morning. And there's also specifics with respect to coming on an H-1B from abroad. So we'll talk about eligibility. We'll talk about, the 6-year limits and cap exemptions. So employment on H-1B, an H-1B visa holder must continue to be employed by the petitioning employer to stay in status on H-1B. In the United States, you have to have a visa status if you're not a citizen. You have to have some basis for how you're in the United States. And different visa categories delegate different duties or different positions that you hold in the United States. This PowerPoint is strictly employment-based immigration. Family-based immigration is very different. So please keep that in mind. This is employment-based immigration. So there are specific rules relating to this avenue of the law. So to get on H-1B to begin with, you've got to go through CAP. So the first step in CAP is to be registered. A company is going to make you an offered position because a company is going to have a position available for you, whether you're in the United States or you're in, whatever country abroad. And based off of that position that's available, they're going to register your name in a lottery. The lottery is called CAP because there is a cap to how many people can be selected to get on that particular visa. The H-1B has a cap. And in order to meet that cap, you must be selected from the valid registration that you've input. With that being said, there's a little nuance to the cap process. There's a bachelor's cap and there's a master's cap. The master's cap, in order to qualify for the master's cap, requires an individual to have at least a master's degree in a specific specialty from a United States university with an accredited university with credentials that are accredited. So there are some universities in the United States that are not accredited. Candidates that graduate from those universities are not eligible for the master's cap. The advantage to the master's cap is usually a 16% higher chance of being selected in the cap. It's a separate pool, so it increases your likelihood of being selected. And then the main cap is for candidates who hold a bachelor's degree or higher in a specific specialty. The eligibility to even get registered, because please be mindful that in order to register, you have to qualify for the position on H-1B, and to be on H-1B, you have to have a theoretical and practical application of a body of highly specialized knowledge in a field of human endeavor. And as listed on the PowerPoint, there's a broad array of what would be considered a human endeavor. It's biotechnology, chemistry, computing, architecture. Most of what we see here at the firm is computer science-based positions or IT-related positions, just because that's, what's the most in demand these days and probably what's going to be in the future. As mentioned on the slide, the foreign worker must possess at least a bachelor's degree or equivalent and state licensure if required to practice in that field. For example, in architecture, you have to be licensed in your state to be, a stamping architect. The H-1B work authorization is strictly limited to the employment of the sponsoring employer. So what that means is the position that's been offered that you've registered, that has registered you in the CAP. And then once CAP selections happen and you're a selected registrant, that employer can sponsor you, but you can't take that, selection to another employer and say, can you sponsor me? Again, because, it's relating to one offered position. So employment on H-1B, assuming that you've gone through registration and were selected and file your H-1B visa, your employer would get you an approval, and it would be in 3-year increments. So it would start on October 1st, ideally, and then end, on November 30th, 2026 for this year's cap. During that time, you must be employed in the position that you've stated on the H1B that was petitioned upon your cap approval. So, for example, if I get on H1B as an attorney and I say, Joseph Calabat petitions for me, and I work under Joseph Calabat, and I state the specific duties that I work as an attorney, I'm not authorized to go work down the road at Ford as an attorney, because that's not what was stated on my H1B. If I decide to change employers, or if I got, fired for some reason, I have to find another employer that's compatible with my H1B status and file something called a transfer. This is a nuanced law that, occurred in January 2017, but there's a 60-day grace period. So essentially, getting on H and staying on H is imperative in the entire, is imperative for the beginning process of what you might call immigrant's intent, which is going to be discussed in the next slide. If a transfer of employment is not possible and you do lose your position, the beneficiary, so me, myself, would have to leave the United States or apply for a change of status. So I must get on another visa because my H1B would no longer be valid. So this is a change of status, which I'm going to come back to. First, I'd like to discuss immigrant intent, which I can probably do without a slide. There are certain visas in the United States that have a certain intent. For example, if I'm here as a student on F1, I do not have an immigrant intent. What I'm telling the United States is, United States, I'm coming, I'm going to study, I'm going to get my bachelor's degree or master's degree, and then I'm going to go home to my home country. However, also some of the B visa also does not have the requisite intent. But say I come in on L1, I do have a dual intent. If I come in on H1B, I do have a dual intent. What that means is my visa itself is telling the United States, I want to work here and maybe go back, but maybe I want to stay and get my green card and eventually my citizenship. Another visa type that doesn't have dual intent is called the TN, and it's a North American visa. It's a visa for certain candidates in specific specialties in Canada and Mexico, and they can come into the United States. But again, they don't have the intent to stay. So their green card process becomes a little bit more complicated. The nice thing about H1B, and the reason why most people want to get on the H1B, is because of that dual intent. So with that being said, an L1 visa, just to give you background on it, it must show the following: a foreign entity related to the company in the United States, either as a parent, branch, affiliate, or subsidiary, are conducting business with each other. So let's say there's a Joseph Calabat in the United States and there's a Joseph Calabat in India. Obviously, they're two separate and distinct entities, but they may have parent affiliations, or it may be a subsidiary, or there may be a back office in India, or whatever it might be. There has to be some intra-company relationship, which means there's some overlap. And if that initial threshold is met and the companies are related, then the employee that we're petitioning for on L would have to have worked for that entity abroad, so the one in India, for at least one continuous year in a managerial, executive, or specialized knowledge capacity within the last 3 years. And then the third, qualification for the L1 visa is that the employee will work in the United States in the same managerial, executive, or specialized knowledge capacity. Essentially, what this means is that this is such an elevated position that, yes, I need to take this candidate from this company to this company because of the nature of the managerial, supervisory, executive, or specialized knowledge that this candidate holds. That's why they're eligible for such a visa. So these L1 candidates come in and, if they wish to accept a new job offer for another employer, oftentimes this is the route that they want to take. They want to get off L1 and get on H1B. That way they can switch employers. That's the main thing about L1s to H1B. It's usually that they want to change jobs or they want to change employers. However, they're still subject to the H1B cap, and that overlapping 6-year limitation, which I don't think I've mentioned yet. The H1B, you can be on H1B in 3-year increments, and 2 of them, so 6 years total. The L1 time that you spend eats up on that 6-year limit, so it counts towards that 6-year limit. And then I'll let Scarlett explain how to, I guess, be an exception to the 6-year limit, or what you have to do in order to extend that 6-year limit on H1B or L. If her microphone works, Scarlett?
Can you hear me?
Yeah.
Okay. So typically when you're on a status like H1B, you only have 6 years to remain on that status, because while H1B is a non-immigrant intent visa, it's a dual intent visa. It's still a non-immigrant intent visa initially, while it has that dual underlying intent. So because of that non-immigrant initial visa, it means it's a temporary visa, which is given in 3-year increments. And the max you can be here without showing you may have a dual intent of an immigrant intent is up to 6 years, unless you can show you do have an immigrant intent. The only way, of course, to show you have immigrant intent is to start an immigrant petition. When you're on an employment-based visa like the H1B, the only way to get an immigrant petition started for you is to have whoever sponsored your H1B also say they're going to sponsor you for a full-time position in the United States, where you stay and remain as an employee of that company as a green card holder, because they no longer want you to leave. They want you to stay on their team. They do this by filing a labor certification with the Department of Labor called the PERM. Once that's approved, they file what's called an I-140, which is an immigrant petition for employment-based companies, employment-based positions in the United States. And if the I-140 is approved, that shows your immigrant intent. When you have that approved I-140, what you're able to do is you can continue staying in the US on your H1B visa, showing you're no longer on just a temporary visa, but you've gone past that with your new immigrant intent, to allow you to stay here until your green card is approved. As many may know, with the visa bulletin and the backlogs in the visa bulletin, from when somebody becomes eligible to file their final green card step, which is the I-45 adjustment of status, it could be years by the time somebody becomes eligible to file that case, depending on the country they're born into. A country like India, the backlog for EB2s is like 10 years as of now, over 10 years. So, this was given as a relief from USCIS to show that a person can stay here past their 6-year limit and continue to work until they're eligible to file the 45, because it shows their immigrant intent. So if their I-140 is approved and they're basically just waiting in the queue to get eligible to file the 45, they're able to stay and continue extending their H1B for the increment of 3 years until they're eligible to file their 45. And that's how they're able to stay here. If somebody is not able to get that offer of permanent employment with their company to go past that 3-year, the 6-year limit, then you wouldn't be able to show USCIS you have this underlying immigrant intent that keeps you here for past your 6-year limit. You would then have to leave the US because you've maxed out your time. So the only way to go past that time is to show an immigrant intent, which is through an approved I-140 with your company.
So with that being said, those are the benefits of being on L1 or H1B, because the path to the green card is pretty much declared upon entry onto that specific visa status. Which brings us to the next visa status that's typically who gets on H1B. It's F1, people on F1, so students. They graduate, but they want to stay. The F1 itself is not a dual intent visa. It's a non-immigrant intent visa, which means that I'm going to come study and go back to my home country. While Sometimes these candidates, they don't want to go back to their home country. They want to stay in the United States, and they also want to get on the path to the green card. So they usually select a dual intent visa, which is the H1B. And obviously they qualify for the H1B because they just finished, their bachelor's degree or a master's degree in a specific specialty. These candidates go through certain statuses that may authorize them to temporarily work, particularly CPT or OPT are branches of the F1 or subsections, you can say, of the F1 visa. And really it's practical training that the university pretty much coordinates. And the basis of these practical trainings is to advance their education in whatever specialty that they're majoring in. So if it's computer science, they may go work for a big IT company, etc. On OPT, you must apply for and receive work authorization in the form of an EAD. It's a specific form that's filed. It's called an I-765. That employment authorization allows them to get a social security number and get paid. An issue with the F1 to the H1B is that sometimes people graduate, but the H1B doesn't come on time. So there's a gap in their status. So they may have finished their degree in, say, February or March or April, but their cap approval doesn't activate, or their cap approval, which means their H1B approval, does not activate until October. There is something called the cap gap, and depending on the information, that's pretty case by case. And if applicable, it can extend their F1 status until their H1B gets activated. Again, F1 is not it's a single intent visa. It's not dual intent. You don't have the intent to stay, but you can get the intent to stay when you switch onto a separate status like L or H or O or whatever you may qualify for. The third type of visa is, sorry, go ahead.
If I can jump really fast, if you don't mind, Michelle.
No, of course.
With the F1 status, such as the CPT, OPT, whatever status you're on, it does not necessarily mean you can't have an immigrant petition filed for you. The issues that can come up there is because the F1 status is not a dual intent status, it's a non-immigrant intent status. There are several things you have to keep in mind when trying to switch over and then suddenly going into a green card immigrant petition. Because with the gap that we were talking about, with the long eligibility period that you have to wait for when you finally become eligible for 40-45, as many know, your CPT, OPT can only last you for so long if you're not continually going from school to school and trying to get on a new program. So it's not something that's reliable to keep you in the US up until you're eligible to apply for your adjustment of status, which is 10 plus years. And even more so than that, every time you try to go and apply for an extension on your F1 visas and stuff, even if you have an I-140 that was filed for you and approved for you, using that to stay, this will always be in a record that you have an I-140 that's filed. And every time when you try to file your extension of your F1 visa, you have this immigrant petition that's sitting there that USCIS can always look into and say, oh, well, why are you trying to extend this non-immigrant visa? You clearly have immigrant intent with this immigrant petition. It should not, by the end of it, stop you from extending your F visa, but it's something that can always be questioned. And it can also hinder your travel because you're not allowed to travel on a non-immigrant intent visa if you have an immigrant intent petition. So even if you file an I-140 with a company because they want to file a green card for you, but you're still on F status, every time you try to leave and come back, they may stop you from entering the US because they see that I-140 that's there, and they'll say, you're not allowed to enter the US on a non-immigrant intent visa. If you have this immigrant intent petition going on, it's contradictory to your visa. So they may even take the visa away from you when trying to enter on an F visa if you've already filed an I-140 while having that F visa. So you run into many issues about your intent and whether you're allowed to stay on a certain visa in the US, and especially when you travel, which is why we typically advise people if they're on F2 and if they have any kind of intent in the future to stay in the US and hopefully get sponsored and move on to get a green card in the future to switch over to a dual intent visa if they're able to, which is why most of our applicants that come in for registering under the H are students, because they're all trying to get on H1B. It's a better deal for them in the future to try to get a green card.
Thank you, Scarlett.
Mm-hmm.
And then, for the foregoing reasons with the F1, the B1 is also a problematic visa because there is single intent. So it's intended for international visitors who come to the United States for business reasons on the B1. And the B2 is purely just visit for some specific reason. The B1 can include conferences, conventions, meetings, estate settlements, contract negotiations, and many other things. The main drawback to using the B1 as a medium by which to obtain H1B status is a short period of stay. So the way that it works on the B visa is that there's increments that you can stay, and it can exceed 6 months. Even if it looks like you can stay a lot longer when your visa actually gets stamped, but the amount of time you can stay in the US is too short. And because of that short amount of time, it's not enough time to secure your H1B visa. Again, why do people want to switch from this visa to this visa? It's usually because you want that dual intent, because most people do want to stay in the United States and eventually get on the path to the green card. For the reasons that that parallel what Scarlett just explained with the F1, the B1 is also going to be problematic. If you can't stay long enough, it's going to be kind of a, again, you would be disclosing different information to the United States. On one hand, you just want to come visit. On the other hand, you want to stay. So there's going to be complications that arise from being on that specific status, which is why most people do end up getting on the dual intent visas. It's not exhaustive to the H1B. I mean, like I said, there's the L, there's a lot of visas that are dual intent, but it would depend on what you qualify for and also who's petitioning for you. So with that being said, travel. As Scarlett mentioned, travel can become problematic. Sorry. When an H1B worker travels outside the United States, other than to Canada or Mexico, he or she must have the valid visa stamped on his or her passport for re-entry in the United States. If the worker has an expired stamp, but an unexpired I-797, it should say approval, he or she will need to appear in the U.S. Embassy to get a new stamp. So if you're an Indian national and you're in Dubai, you would need to go to the Emirati U.S. Embassy. That way you can get your visa stamp because that's where you're living at the time. If you're in India, you would have to go to one of the consulates in India that are from the United States. Sometimes an H1B worker can be required to undergo something called administrative processing, which is extra background checks of different types. Under the current rules, these checks are supposed to take 10 days or less, but in some cases have lasted years. And this point was to speak to the people that are in India abroad. Coming in on the H1B is not just specific to the I-797 petition. These positions do get verified, either by USCIS, like in the United States, maybe they'll come do a site visit for the employer sponsoring you, or sometimes just the position itself. Sometimes they look at the position and they say, I don't think, this meets the requisite. The difficulty with the happy medium of marrying USCIS and the State Department is also what becomes difficult. The consulates are run by the U.S. State Department. However, USCIS is separate. I wouldn't say separate and distinct. It overlaps, but it has its own case law that governs how USCIS adjudicates cases. So just because you get an I-797 approval from USCIS doesn't necessarily mean that the consulate is going to approve your visa stamping appointment. Oftentimes it has to do with the interview and what happened or what was said or, an inconsistency. Sometimes it just has to do with the position. Maybe they don't think you're qualified. But it's not an automatic thing. It's not as if just because I got approved by USCIS, my consulate's gonna, give me a free and flying colored stamp for me to fly into the United States the next day. It's a little bit more complicated than that. But I would say 9 times out of 10, it goes smoothly. If you have a valid approval, it's always able to be challenged at the consulate level, even if they ask for additional scrutiny or more documentation. The nice thing about having a sponsoring employer with attorneys is we help respond to those requests and kind of smooth out the wrinkles for you to enter in more smoothly. So that's why it's nice to have an employer who also knows what they're doing, because if you just have an H1B sponsoring employer who doesn't, sometimes it's the candidate who may end up losing at the end. Companies like Cogent and similarly situated companies are well versed in the entire process and have valid positions that they vet, and they vet their candidates. So that's also very important in the entire process. And then just to end with a fun fact, an individual with a valid H1B visa does not need a visa to enter Costa Rica for tourism for up to 30 days. The H1B visa must be stamped in the passport and be valid for at least 6 months. The passport needs to be valid for at least 6 months after entering Costa Rica. And then there's a lot of other Latin American nations and Asian countries that also allow travel without a stamp if you're on a valid visa issued by the United States. Mostly that was just to show that the immigrant intent is pretty much letting other countries know, like, I'm not going to stay here. I'm probably going to go to the United States and hopefully get on my green card eventually. So with that being said, we're open to any questions. This was not an exhaustive discussion. It was an overview. I'm sure we missed a lot of information, but we're happy to help clarify or answer any questions that were or weren't addressed. And then I just want to thank Usha and the Cogent team for their help and assistance and just being lovely to work with.
Thanks a lot, Michelle. Thanks a lot, Scarlett, for joining this call and taking care of everything. It is, H1B itself an extensive one, and you have given a brief note about it. And if you have any questions, you can just post it here and you can ask us. Few questions already Scarlett has responded, I think so, right, Scarlett?
Yeah, I saw one on there, something about the IT field.
Yeah, one question I'm seeing is, I did my MS in biomedical engineering, which is under STEM. Am I allowed to work in IT on OPT? That is one question we have it, please. Yeah.
So I answered in the chat as well, but just so people know, it is very important that you when applying for an H1B, that you are found eligible for the position that's being applied for you. A lot of positions I see that we're filing are for IT related positions, and sometimes we'll see when we're registering people, the degree that they have aren't IT related. This can be overcome in a few ways. The most prominent is to show that you have IT related experience. So USCIS has taken to accept experience in place or along with education. If you can show that you have had at least 3 years of experience, if you've already completed a bachelor in a different field and you can show 3 years of experience or more, preferably more, in an IT related field, what we can do is we can use your experience combined with your education to get an evaluation that will treat your experience like education, to where you will then be put into a related field of an IT position, and you could use that combined education and experience evaluation to file with USCIS for an IT related position on your H1B.
Okay. Thanks, Scarlett. Thanks for your detailed explanation. The next question is, talk about green card lottery, please. That opens a whole world. Yeah, how it works.
Oh, I'm sorry. Just to piggyback on that, Master of Science in Biomedical Engineering, which is under STEM, am I allowed to work in IT under OPT?
Mm-hmm.
A lot of times we get RFEs, which are requests for evidence, when people are changing statuses. Because my thought process is you want to get on OPT to eventually go through CAP and get on H1B. Sometimes that change of status CAP case does get flagged and does have a request for evidence, because USCIS does know that people abuse these, optical practical training, opportunities to work. the whole point of the practical training is to advance whatever degree that you're studying in. So if you're studying in biomedical engineering, the best thing that I would give you advice for is not to just go to an IT company, but maybe a medically based IT company, which there is a lot of. A lot of these engineering companies are doing, IT work for huge hospitals to streamline their, health charts that the people have an app for, whatever it is. That would give you both, the best of both worlds, in my opinion. So I just wanted to answer that. Yeah. So it would need to be related to your master's degree. It can't be unrelated, because then that would challenge whether you were in status on your F1, whether your OPT was legitimate. And also that's something you have to discuss with your DSO. So your school has to approve what your OPT is in and set the requirements for OPT. It's not as relaxed as you might think. You do have to meet the regulations to be valid on F1 to ever eventually move out of F1 onto another status, or eventually, get on the green card path.
Oh, thanks a lot for detailed explanation on that, Michelle and Scarlett.
No problem.
Thanks for Lydia.
So in your next question here, where you're asking about the lottery, green card lottery. So there isn't really a lottery for the green card. It's not like an H1B lottery where you have to register to get on H1B. With the green card, what you need is a valid future sponsorship. So it needs to be an employer that's saying that they're going to sponsor you for a position that will remain open up until you're able to get the green card. And that's the position you'll take with their company once you have the green card. So it really doesn't matter if you're with that company right now. What it's saying is that we are promising to employ you in the future once you are a green card holder. So it has to be a position that remains open for you up until you receive your green card. And to show that, you have to file a perm, an I-140, and a 485. And like I said, the backlog only comes in for depending on which country you're born into, because there's a cap limit in a way, not for a lottery, but there's a limit on how many immigrant visa numbers are available to each country and each people every year filing for a green card for an immigrant visa number. So the backlogs come in based on how many immigrant visa numbers are available to each country for that year that's being filed and assigned. So what you check is the Department of State Visa Bulletin. You can go on there. They update it every month, and every month they show you basically the year they're in for eligibility and how many visa numbers they have available, and up until which date a person can file a 45 based on their priority date. And their priority date is the date their perm is filed, which is the labor applications filed with Department of Labor to get started for your I-140 immigrant petition. The day that's filed, you are then placed in a queue, and that's your priority date. And that date is used, that requires when you'll become eligible to file for your final green card once that date is current, according to the visa bulletin.
And then just piggying off of that, I don't know if you mean specifically for employment-based green cards, but there's the diversity visa, and that's a visa lottery as well. But that's not employment-based, so it would just be a whole nother conversation. But essentially, it's open to all different countries or specific countries abroad. Some countries are disqualified from entering into the diversity visa lottery, but that can help you get an immigrant petition started. It's actually how my uncle came to the United States. He won the diversity visa lottery and then ended up getting his green card that way. Yeah.
Oh, that's good to know, Michelle. Yeah, I'm glad.
And I saw a different question that asked about the Dropbox eligibility. So you're eligible for Dropbox if you've had a previous visa approved with the United States. So it doesn't need to be an H1B visa. It can be B1, B2, F1. A lot of different visas satisfy the requirements. And then applicants who were denied a visa for any reason in the past are not eligible for Dropbox. And essentially for anybody who doesn't know what Dropbox is, it's just an opportunity to get your visa stamped on your passport without an interview.
Hi, I have a question. My name is Lloyd. Can I speak?
Yes, of course.
Yes.
Yeah. Hi. Hi, Scarlett, Michelle. Thanks for providing the information. My question is, I am currently in US on H4 visa as a dependent. So if I get through the H1B lottery from any organization and if my petition is approved, so can I start working on the approved petition and then probably when I visit my home country, get the visa stamped and come back? Or do I need to go with the approved petition to my home country, get the visa stamp, and then come back and start working?
So that really depends on how you file your H1B Cap petition. If you're selected a lottery and you're on H4 visa, you can file for a change of status, which
Okay.
means you don't have to leave to change your status. So if you were to file an H1B petition that requests an automatic change of status, if your petition is approved, starting from 10/1 of that year, so if you were selected this year, starting from October 1st, you wouldn't have to do anything additional. You would just automatically be on H1B visa and start working on H1B visa with the company starting from 10/1.
Okay.
Some people don't select that, or maybe once they file the H1, they travel, which is another reason maybe you won't get automatic change of status. If you do something like that, it takes that automatic change of status option away. Some people, maybe they don't want to stay up until they leave, or maybe they have travel plans. And so what they instead select is consular processing. So they ask for the case to be approved for consular only, which means that once the 10/1 day hits, they don't automatically change to H1. They would need to go abroad to get an H1B stamp to come back in and be on H1.
Okay. All right. So I need not go back. So of course I did try my luck from Cogent, but it didn't get through. But anyways, I'm just hoping for something good. But okay, this answers, like I can start working from 1st October 2023 from Cogent if my petition is approved. I need not go back. But if I travel to my home country, then I need to stamp the visa and come back, right?
That's right. If you travel to your home country, even after you already started work on an H1B visa here, the next time you travel to be able to come back, you don't have that visa stamp in your passport yet. You'd need to get it to come in on H1B.
All right. Okay. And as you said just now, will it be a Dropbox because I already have an H4? So
most likely not in that case. Dropbox eligibility is typically if you're trying to do an extension or an H1 that you already have, they'll call you in for an interview.
All right. Okay. Okay. Thanks.
Just to add to that point, Lloyd, while you are filing the DS-160, it shows you whether it pops up saying that whether you are eligible for Dropbox or not.
Oh, okay.
Yeah.
Okay. Yeah. Okay.
Thanks, Scarlett. Yeah.
And then for Sri Devi, I see that you asked how difficult is it for non-STEM degree graduates to get on H1B. So it would really depend on who's petitioning. So if I have a master's degree in law or something, there are attorneys that come from London or other European countries or even countries abroad that come in as attorneys on H1B. It depends on who's petitioning for you, and is your education related to the position offered. If it's an IT related position that's being offered, you should have an IT related educational background. Even if you don't have the degree certificates, maybe you have 5 years of experience that can get you an equivalency. It would just need to be a petition that would be cohesive and would make sense, right? Because the visa is specific to people that are specialists in certain subjects. It wouldn't make sense if somebody who has a hairdressing degree goes and works as an architect. You just can't. Not even that the first would qualify, but just to prove my point that it needs to be related to the position. So it's always case by case. It could be extremely difficult, it could be impossible, or it could be 100% easy. It would just depend on the facts that we would get, that would be provided, which is another reason why I said it's very important to have companies that would sponsor you who are like cogent, very cohesive companies that have done this before, that can give you a good, a valid position or job offer, right? All of that is important, because there are companies that don't do that, and they do get flagged by USCIS, and it could be problematic for you when you try to enter. Maybe your visa would be denied at the consulate, or maybe your petition would be revoked later on in the United States. It's very important that you have somebody who's sponsoring you very legitimately and does good work on their end. That way you're not in any kind of jeopardy down the line. So I don't see any other questions on the meeting chat. Oh, good. I'm happy I answered your question.
Yeah. Yeah, that's all we see the questions on the meeting chat right now, Michelle, Scarlett. Yeah.
Yeah. You guys can
Okay.
always email me if you have any other questions, or email Usha and she could forward them to me. If
Yeah.
anything comes up later, we're happy to help with whatever you guys need help with. And I think
We are sharing a link here.
Yeah, I'm sure. Yeah, Ravi.
Questions.
I'm sharing a link here, Ravi. Yeah. Please go ahead, Ravi. Yeah, I shared it here.
Yeah.
thank you, Rob.
Can you answer this question? I think many of them may not be trying to ask this question. I'm trying to ask on behalf of the candidates. Some of these candidates have filed their H1B from multiple employers. And if it gets picked up, and how the USCIS is processing those applications, what would be the consequences also in future?
Sure. So it's a problem that we're seeing a lot lately. A lot of people double, triple, quadruple registered in the lottery. The unfortunate thing is, this is the United States. They have the proper IT systems. We're inputting everything on a certain, registry. It just takes a couple, navigations for them to see how many times somebody with the same exact name, same exact passport number, and same exact birthday come up. My experience in the past month is everybody who is double registered got selected. Double, triple, quadruple. I think, in my opinion, it's just a statement from the government, like, I know that you registered more than once, and that's why I selected you. It doesn't necessarily preclude that individual from petitioning, because the company makes these attestations that sometimes they just don't know what these individuals did. I don't know how a company would have all the knowledge that one person registered with their company and then went and registered with another company. They have to swear at the end of their registration process that they didn't know that happened. And most of the time that's the truth. Companies don't always know. However, companies that have overlapping, I guess, or like suspicious connections, or share employees, or some kind of relationship between the companies, if they double registered, it puts those companies in very big jeopardy. And then the final thing that might occur is you might have no problem, but then in a couple of years, USCIS can come, based off of the CAP case that was approved, say, actually maybe, this shouldn't have been approved, and give you something called the notice of intent to deny. It elevates the risk. And there was a lot of abuse this round, or this year's CAP, with how many people multi-registered to increase their probability of getting selected in the CAP. And I'm sure, we'll see the aftermath of it in the coming time. But as far as I'm concerned, I think that it is noted. I don't think that, I don't think the United States is so oblivious, right? It's a government entity. They know what's going on.
If I
And then
can
I'll
give
yield to
you-
Scarlett on that too. Sorry, Scarlett, go ahead. You
Yeah,
probably
no
more.
problem. If I can give you some kind of idea in numbers, just so you know how much USCIS does know about what's happening. There was something that was released in AILA recently that very clearly showed the number of registrants for each year from 2021 to now, and the total number of registrants as comparable to how many were beneficiaries with no other registrations and how many were beneficiaries with multiple eligible registrations that were filed under several companies. For last year's cap, there was a total of 483,000 total registrations. 309,000 about of those were beneficiaries with only one registration for a company. And 165,000 of those were beneficiaries that were multiple beneficiaries that were shown up in other companies' registrations. That was last year's. This year's cap, there was a total of 780 registrations. 350,000 of those registrations were original beneficiaries with only one company, and 408,000 of those registrations were multiple beneficiaries filing under several companies, which is even more than the number of the single registrants under one company. So you're talking about from last year to this year, the number of multiple beneficiaries counted went from 165,000 to 408,000. This is why the number of total registrations seems so astronomical. Last year, total registrations that were filed were 483,000. This year was 780,000. But of that 780, 408 of those were multiple registrants. They weren't just, one person. What does this do? Of course, it decreases the chance of people that are, say, a single filer under a single company that's able to register and actually get a position with that company. I unfortunately had companies that filed this year who had master's students that are on CPT, OPT that are currently working with them at their companies that filed under the master's cap and weren't selected at all. Of course, they have positions there. They work with that company right now on, on their EAD under their OPT, but they were not selected. And it's due to the multiple selections for the multiple registrations that were filed for several people. So USCIS knows these numbers. They've recorded these numbers. They see what's happening. They see the trend for the past several years and how the trend has grown. So they know how the system is being used as of now. Why are they letting it go through? Because they can. And USCIS, unfortunately, is a government that likes to play what I call the long game. The long game means they're going to continue to let people do this so that they can track it and follow it and see where people are doing it intentionally so that they can get, people down for fraud for it and maybe even have them, charged or bring fines upon companies and things if they believe the company is doing this intentionally. They'll do this so they can collect enough evidence to see how they can change cap registration in the future. They may take away fees and numbers, change opportunities, change how the registration system is even being used at the moment. Maybe they're going to make sure in a few years, if you register, you have to show that you have to have an actual job, that's open to the person that you're registering under, which you don't have to show as of now when you register. Now you just have to show the name, the passport number, and the birth date of the person. They could change it to where, they have to show what is the position you're going to be filing for this person if they are selected. And do all these companies have these position openings for this person that's, going to several companies at once, right? Companies are the ones that are going to get hit hard with this, because if USCIS can prove that the company knew or colluded with another company to have somebody multiple registry to increase their chances into getting into the lottery, then they'll come after the company and say that they went against the attestations that they certify that they were doing at the end of the registration, that you attested that these are valid opportunities, that you were not colluding with another employer, that you were not increasing the chance of an individual to be selected and to get a job position. These cases are being accepted as of now. They're selected in the lottery. When we file them, does that mean that USCIS won't scrutinize them more? Of course not. USCIS has the numbers. They will scrutinize the case. They're increasing their FDNS site visits. They're increasing their calls to both the petitioners and employees. They're increasing their calls to clients. If they're in-house, they will visit the in-house location. They are looking to see if these are valid job opportunities. So they are trying to crack down on whether these are legitimate positions that were registered or not. So what it all goes to show is yes, you got selected, but at what detriment, if there is one? If you're getting selected and your case goes through and USCIS finds it to be a fraudulent case or denies it for that case, have you ruined your shot in the future? Every time you try to file something with USCIS, are you now going to be put, on a flag? Are you flagged in their system? Do they know your name? Do they know the company? Do they know that every time you get a case through, can they look into it more? Are they going to scrutinize every case you file? It's possible, right? So they're just trying to collect data at this point, which is why we always try to tell people, stay as legitimate as possible as you can with these open registrations that you have. Is there a valid position for you? If you're a company, we try to tell companies, when you're registering somebody, really try to see if they're out there trying to register with multiple other people at the same time. Have them sign an affidavit, have them, give you some kind of word on their, that they're not going out and registering under 10 other companies at the same time. You don't want them to put a flag on your company just because they wanted to increase their chances of selection or not. It's just very important that we know that this is a database for a reason, that they put everything online for a reason. It's so they can read it better. And they do have the numbers and they do have the information they need to be able to follow up on what they need to follow up to see what cases are legitimate and which ones aren't at this point.
Beautiful explanation, Scarlett. Thanks a lot for your valid explanation on this. Yeah, good question, Hari. Right now, that is a topic right now. Every call, they are talking about this multiple selection. And following that, one person here, Virendra Prandela, has asked, what about previous year if a person filed for 2 registrations but not picked up anyway?
So if they filed for 2, so what USCIS is following is not just this year's, but they're following previous years.
Previous years.
We saw an example of a notice of intent to deny. I will not list the company or the name of anybody, but if there was a notice of intent to deny that was posted somewhere from USCIS on a CAP registration case that was filed this year. And the reason they sent a notice of intent to deny was because the individual was picked up under 4 companies this year, registered under 4 companies, was picked up under 1, filed their CAP case under that 1 company. And they questioned the legitimacy of that job offer to this person because they also pulled that last year, this person had also registered under 4 other companies, wasn't selected last year, but did mention that they saw that they registered last year under 4 other companies, same companies, weren't selected at all, and this year was selected. So they do track and see, even if this happened last year, you're doing it again this year. We know how many companies you were registered under last year. We know how many companies you were registered under this year. We see that you were selected. Please tell us what's going on. Basically, that's what the notice of intent to deny said. They said, give us evidence that this wasn't a fraudulent petition. But it does show that they are not just tracking this year, they're tracking the previous years as well.
Oh, good to know, Scarlett, that they are taking care of, going over the years of registration. Thanks, Scarlett. Thanks, Michelle. Can we wrap up the call, or do you have any other questions? Or do you want to add any other points here, Hari, Ravi, or Michelle?
No, but if anybody has any other questions, like I said, you're just happy to answer. I think somebody just asked, they filed 1 and were picked up once. Yeah, there's no problem.
Oh, yeah.
Yeah, there's no problem with somebody who didn't do anything wrong. Essentially, the regulations require that, the idea behind it is there's one position, right? There's one position is why you're registering, which was the beginning of the slideshows. For that one position, it's assumed that that's the truth. I mean, very rarely do 4 companies fight over the same worker, right? So there wouldn't be
Right.
4 of the same offered position. So if you have one and you did it right, you're fine. If it wasn't done right, yeah, maybe it won't be a big deal now. It may be later. And as Scarlett mentioned, mostly we're advising employers to be cautious because that's who's going to end up getting the heat of it, right? For the individual candidate, maybe it'll affect you in 3 years when they want to revoke your original cap petition, or 5 years or 7 years, or I don't know, but it is definitely something that's flagged, and they do have your most important information. That's also something not to ignore. They have your name, your full name, your passport number, and your birth date. It's very hard to duplicate that. So I just want to thank Ravi and Usha and Scarlett and all the participants, especially, like I said, the people in India who tuned in so late or early, whatever you want to say about it.
Yeah.
And we're happy to help with whatever you guys may need moving forward.
Yeah, thank you. Thank you, Scarlett. Thank you, Michelle, for this wonderful session. And
Of course.
yeah, a few of the audience joined late. So just in case you want to have a look at this, just go to our website, LetUsTalkIt.com, LetUsTalkIt on YouTube, and then you will be able to, see the recording. Okay, if you want to share it with your friends, and we do have a form which Usha has shared. So if you have any questions, let me repost that. Feel free to, submit this quick form, and we'll get back to you with the right answers.
Sure. Great. Thank you, everyone. Thank you so much for having us.
Thanks a lot for joining Michelle and Scarlett. So hopefully we'll get back to you in the next future. We'll talk to Michelle and Scarlett and come with the next topic and let you know about the next dates, please, team.
Thank you. We really look forward to
Yeah,
it. I hope you guys have
yeah.
a great evening.
Thank you.
Thank you. Thank you,
Thanks,
everyone.